Last week we got into this basis of this whole idea of what is discrimination. We gave you a background, probably a little more boring background than you wanted, of the difference between federal discrimination, state discrimination, and then remember all those times. And those times are important. 300 for what, by way of review? I'm sorry, what day? No, you're right. 300 or 180. Federal court, if I want to file a charge of discrimination in federal law, it has to be what? 300. And if I file in their state, what? 180. Okay. All right. Everybody got that? All right. Now, let's talk about the basic types of discrimination. When I just talk about types of discrimination, I'm not talking age, race, sex, gender, those things. I'm talking both disparate, D-I-S-P-A-R-A-T-E, treatment, or disparate impact. Okay? Disparate treatment or disparate impact. Tell me the difference between those two.
Disparate treatment is intentional and impact is unintentional.
All right. Treatment is intentional. Impact is unintentional. I don't want to confuse it too much. Impact could be intentional. It's just guised. It's just disguised, if you will. Okay? And it may actually be unintentional. But don't let people fool you. There can be discrimination that on its face looks unintentional, but really is intentional. And we can talk about that. Give me an example of intentional discrimination. Jackie?
That would be like name calling or like bullying, just harassment.
Okay.
Like that, or being told specifically like you're not getting this because of some factor
Okay.
about yourself.
You're not getting this job because you're a female. All right? It's name calling, bullying. It's something that is intentionally designed to discriminate. All right? Let me give you the qualifications. Well, give me an example before we get on. Give me and look at each one. Give me an example of what might be impact. Amanda?
Statistics showing that only males were promoted and no females?
Yeah. Statistics showing that only males were promoted and no females. And the reason is, maybe an agility test or a lifting test, and they required more for females than they did males on a percentage or whatever. All right? Those are examples. We'll come back and look at all those. Let's talk about the intentional discrimination first. All right? Disparate treatment. 4 main qualities that you have to prove intentional discrimination. In order to prove intentional discrimination, the employee has to show that he is in a protected class. All right? Qualification number 1. Let me give these to you and then we'll come back and look at it. That the employee is in a protected class. Number 2, that the employee is qualified and in fact applied for the position. This would be like a hiring position, if you will. Okay? But qualified and or applied. Third, that the plaintiff was not hired or that the employee was not hired. Right? And fourth, that the employer looked for other applicants or hired someone else. Now, these 4 really address the hiring, but they're not much different than if you're already hired and you're being discriminated against. You still have to show, if you're already hired, you have to show that you were in a protected class, okay? That you were qualified to do the job, okay? And that you suffered some kind of adverse consequence as a result of your gender or race or whatever it be. I think the McDonnell-Douglas test, and I think that was, you may have read that. The McDonnell-Douglas test is the one that talks about the hiring. When you get right down to it, you have to show, here's what you really have to show. And I don't care how you do it when we talk about it later on or when you get the opportunity to share what knowledge you know. But you got to be in a protected class. Okay. You had to suffer some kind of impact or adverse decision. And it had to be causally connected to your protected class. That's what it really all boils down to. Okay. So, backing up. What is a protected class?
Native American.
Native American. All right. Give me another example of protected class.
African American.
African American.
Female.
Female. Any others? I mean, there are all kinds. We haven't talked about them yet. Hispanic. All right.
Disabled.
Disabled. All right. We'll talk about disability discrimination. What else? I'm having cataract. I had cataract surgery last week. What's that? Actually, go ahead. What's that mean? That I'm old? Yes. But I will just have each of you know that the nurse said, "You are my youngest patient for the day." And boy, that was the truth. It was like, "Have you got anything in what?" You know, I mean, they were, and that's not discrimination. But, well, they didn't have, some of them didn't have their hearing aids turned up. It was, but, no, age is a protected class, all right? Truth of the matter is, there's not any class that's not protected anymore, including white males, okay? Now, there was for a period of time that if you were white male, you really weren't in a protected class. But any class can be protected. Or, any class can be protected. Okay? So, really, once you're in a protected class, which is almost everybody, you have to show that some kind of adverse action was taken against you. And then you have to show it's related to your class status. Now, it is the employee's duty to present that. That's how they make what is called, and you, as you may read about or have read about, what is called a prima facie case. And a prima facie case, that's the language that you see, but that just basically says, I put in enough evidence to show the bare bone essentials to make a case. So for instance, let's take age. Age really is 40 or above. It's really not that old, okay? It's 40 or above. But if I'm making an age discrimination complaint and I file a lawsuit, somehow I got through a right to sue, and I filed a lawsuit, and my lawsuit doesn't show that I'm at least 40 years of age, it only shows that I'm 25, I've not made a prima facie case, okay? So a prima facie case is the bare bones that you have to make in order to show that you can win your case. It's a prima facie case. I've got enough here to at least give us something to talk about. If I'm only 25, I don't have anything to talk about in an age case, all right? Once the employee makes that prima facie case, it is the employer who must then provide a defense to that and show why it really wasn't discrimination. Now, what are the ways that an employer might show a defense? And we'll talk about these in more detail in just a little bit. But let's say somebody has filed an age discrimination that they've shown that they're over 40, so they're in that protected class, if you will, all right? They've shown that they've been fired, okay? And they say, hey, I was fired because of my age. And they allege that in their lawsuit, all right? What does an employer show? What may be in a defense that an employer can show? Jackie?
An employer could show maybe statistics like of people that have been promoted or hired in the past year that have been over that age, or some policy that says that they have to have certain qualifications.
Okay.
Like that they chose qualifications over seniority
Okay.
or something
an employer can show a non-discriminatory reason. Okay? An employer then shows a non-discriminatory reason for the decision. In other words, somebody else was more qualified. Okay? What might be another non-discriminatory reason? Had one 2 weeks ago. Couldn't believe that they actually filed it. But we're going to spend some time addressing it. Person was filed a complaint. They had been terminated. I don't think they were out of state, and so they weren't one of ours here. They complained that they were terminated on the basis of age. Okay? We did, in fact, terminate them. The reason that we terminated them is because this particular employee had a knife in her drawer and said, I hate my supervisor so much that sometimes I'd like to get this knife out and stab him. And we go, whoa, we're going to terminate you for that because we're not going to tolerate any, okay? Will that be a defense? Now, it'll be up to the judge or the jury, whoever, to make that decision. But that was the reason we terminated her. It had nothing to do with her particular age. It was just the fact that, on that particular occasion, for whatever reason, we had no tolerance, zero tolerance policy for violence. All right. So anything that can show that they discriminate or that they terminated for a non-discriminatory reason. Okay. Now let me stop here because I think your book talks about, or the text talks about, the St. Mary's case. Remember that? Anybody remember that? Basically, it's a case that says just because I'm wrong doesn't mean you automatically win. All right? St. Mary's versus Hicks. That just because I'm wrong doesn't mean you automatically win. Is it in there? And then this particular one, okay.
Chapter 8.
Yeah, okay. It may be in the next chapter. We'll talk about whether it's whatever chapter it's in or whatever your readings are in. But let's take that same example that I just used you. We have a person who's over 40, all right, in the protected class. We come back and say we terminated her because she had a knife in her drawer and said she was going to use it against her supervisor. Now, she comes back and says, they know I don't have knives. And we go, yeah, we probably lied about that. The St. Mary's Hicks case says, just because you lie doesn't mean the plaintiff won. Okay? They still have to prove that there was a discrimination reason. Now, if you're on the jury and we've lied about the reason we terminated her, who are you going to believe when it comes time to render your decision? You're going to believe the employee. If we're the ones who've lied to you, you're going to believe the employee. But just because we've lied doesn't mean she automatically wins. Okay, that was the standard of St. Mary's, that the mere fact that the reason given by the employer was false doesn't mean a win for the employee. Really, your defenses have to come down to two things. Either a non-discriminatory reason, which we just talked about, or a bona fide occupational qualification. Bona fide occupational qualification. What is a bona fide occupational qualification?
Is that like
Okay.
a job necessity?
Okay, job necessity. Give me an example of that.
Well, I'm going to use it from another class. Like a fireman, you would most women are not firemen, so, the test that they do in order to be a fireman pretty much excludes a woman.
Okay.
No offense to the women out there.
Well, except that, no, I understand what you're saying. You're right. The majority of firemen are men, okay? But is there anything inherent against a woman being able to be a fire person? Probably not. I'm not sure that the sex itself. Example. I understand what you're saying, but there's nothing inherent about being a female that would prevent you from being a fire person. Whitney.
Is it like if you're a part of the job meant you have to be able to pick up, 100 pounds, or you'd have to be able to stand on your feet? Well, I guess that would, but you have to be able to pick up 100 pounds or 150 pounds and be able to carry it such distances.
Right.
A lot of females probably wouldn't.
Which is why females can't do it. But the qualification is not so much because they're female or male, but because of the requirements for the lifting. And that may have been what you were saying, Donna. Okay?
Yeah, that's kind of where I was going.
Okay, all right. And yeah, it's the same thing. Give you a really clear example, all right? If I'm a member of, pick a religion, I don't care.
Jewish.
Okay, if I'm a Jewish, what else? Mormon? All right. Either one will work, all right? Whether I'm in the Jewish tabernacle or the Mormon tabernacle. I can't have somebody who is a Wicca leading my church, right? What's a Wicca? A witchcraft, yeah. Okay? It's going to be a bona fide occupation, that somebody not going to be practicing witchcraft, all right? And we can break that down even more. If I'm a Catholic, all right, I can turn down a Baptist to lead services. I don't have to hire, all right? That's what we're talking about when we talk about bona fide occupational qualification. Race can never be a bona fide occupational qualification. And why not? Yeah, color of skin doesn't matter. It would absolutely never be a bona fide occupational qualification. Okay? Their sex may be a bona fide occupational qualification. Not very often, but could be. Okay? We'll talk about that more next time. So basically, you have a non-discriminatory reason, that can be a defense, or a bona fide occupational qualification, that can be a defense. All right? Now, you can also, these are kind of defenses that go with everything. You can show that people didn't exhaust their administrative remedies, all right? You can show that your plaintiff didn't exhaust their administrative remedy. What would we mean by an administrative remedy? Huh? An alternative, which is what's the first thing they have to do before they ever file their lawsuit? Show that it was discrimination, but who do they try to show that to before they ever come into court? Yeah. The EEOC, or the Missouri Commission on Human Rights, all right? That's what we call an administrative remedy, all right? So maybe they don't do that and they somehow ended up in court, or they just filed the lawsuit. I mean, you just pay your money and you go file your lawsuit. So that might be a defense. Statute of limitations might be a defense. But when we talk about defenses that are unique to the employment situation, discrimination anyway, it's either a non-discriminatory reason or a bona fide occupational qualification. All right. Now, any questions about that? And as we get into each one, we'll give more examples of intentional discrimination. All right. So as we get into race, we'll talk about it in terms of race. Right now, we're just giving the background. Okay. All right. That's one type of discrimination. That's what we call treatment. What's the other type of discrimination? Impact, which is what? Okay, unintentional, all right? That can show up in several ways. It can show up in the tests. Tests can be a form of discrimination. Height and weight requirements may be a form of discrimination. Educational requirements may be a form of discrimination. And lifting requirements may be a form of discrimination. You may have had in your readings the Griggs versus Duke Power. Anybody remember that case?
that changed, well, it wasn't educational requirements, but in order to kind of get around the new laws, you know, and basically back up their discrimination just in a different form, they're like, oh, now you can't transfer and you have to have these other like aptitude tests that
Yeah,
qualify you.
Yeah, Griggs really is a high school diploma.
Yeah.
Okay, yeah, Griggs is the high school diploma. High school diploma is required, all right? Now, why would a high school diploma requirement be a disparate impact? How could that be discriminatory? Because everybody that works there has to have a high school diploma. So what's discriminatory about that? I mean,
If someone got their GED.
okay, someone got their GED. I mean, but if they got their GED, they didn't get their high school diploma. So we're going to say, hey, you're white, you don't have your high school diploma, I'm not going to hire you. How is that discriminatory against some class?
Is it because that they're being subjected to the lower level paying jobs instead of the higher level?
Anybody that doesn't have their high school diploma, you know, gets the lower paying job. You don't have to, you know, whether you're white, black, African American, Native American, give you whatever you want if you don't have your high school diploma. Okay? How is not having a high school diploma discriminatory? Or can it be discriminatory? Jackie?
It goes back to the idea of impact, and I mean, it was the 60s, and so the result of the policy was that you had your white employees always, you know, met this qualification, but the impact on your African American employees is that they often didn't.
The truth of the matter is, and nobody wants to talk about it, but the truth of the matter is, African Americans at that particular time didn't have high school diplomas. Okay? They weren't given the same opportunity. And the high school diploma itself wasn't necessary for the job, maybe, for the job that they were performing. But by requiring a high school diploma, all right, they were excluding a certain class. All right? They were excluding a certain class. So that's how that can be. If I say, let's say teachers. Let's go to teachers. And let's say that you can't, Missouri State has a policy that says you cannot, if you want to be a teacher at Missouri State, you have to be 6'1". Discriminatory or not? First of all, intentional discrimination? Probably, if we're going to have a policy like that, sure, probably. But does it have a discriminatory impact? Let's assume it's unintentional, okay? Yeah, I know, it is intentional if they were to have that. But let's assume it's unintentional. So we have this policy, we don't know what we're doing, and we have this policy that says, hey, all teachers have to be 6'1" or taller. Discriminatory or not? Yes, all the females are saying yes. Why? Melissa?
Because usually a man would be taller than a woman.
Yeah. Men are generally going to be taller. Not always, but you're going to have more men who are 6 feet. Well, hey, we say we're not going to hire any man who's less than 6'1", okay? That might be discriminatory on a couple of reasons, okay? You might get into some races that typically don't reach the height of 6'1", all right? Give me a race that might not, let's go ahead, be stereotypical. I mean, no, this is discrimination class. Give me an example. Oh, you guys are discriminatory, right? Asians, I heard. But you're exactly right. It can have an impact. So not only on females, okay, but it can have an impact on Asian population, right? So an unintended, if you will. What the employee in this particular case, what the employee in a impact case has to show is that the employer, here's what it all comes down to. The employer uses a particular employment practice that causes a disparate impact against one of the classes protected by Title VII or the state laws. Okay? Basically, the employee has to show that the employer uses a particular employment practice that causes an disparate impact on one of the protected classes. All right. Once the employee shows that, they've pretty much made their, what we call that prima facie case. All right, they pretty much made their prima facie case. Excuse me. So now the employer must demonstrate that the practice is job related for the position in question. Has to be job related and consistent with business necessity. Okay? So once the employee has made this prima facie showing that, hey, your practice has a disparate impact on a protected class, okay, then the employer must show, look, this practice is job related for the particular position and is consistent with business necessity. All right? Now, even if the employer can show that, if the employee can then show that there's another alternative method or another alternative practice or test or whatever, and the employer refuses to adopt it, then the employer may still be guilty of disparate impact, even if they can show that their particular practice is consistent with business qualification or business necessity and job related. Okay, so it has to be job related and consistent with business necessity. But even then, if there's a less strict method. Okay. So somebody tell me here why being 6'1" or 6'2" is a necessary practice for being a teacher.
It's not.
Okay, all right. Yeah, I mean, we're going to make the position. There's no way we can take that position, okay? I mean, we can say it, but there's no way that we can really argue it. Now, let's go back to our Baptist Catholic situation. Somebody argue why it is necessary, necessary not to hire, not to require somebody with a Catholic, I'm not Catholic, so I'm going to butcher this. I'm not, you know, what's your requirements in Catholic? If you want to be a pope, not a pope, that's different, okay? We're not going to go that far. All right, somebody give me a requirement for Catholicism. I should know this. Anybody? Okay, let's reverse it, okay? If the Baptists say you have to graduate from a Baptist seminary, okay, Catholics then are not going to qualify. Is that a job-related practice or consistent with business necessity?
Yeah.
Yeah, and why?
Because Catholics and the Baptists have different beliefs, so it could necessarily, or specific study, like everybody's major.
Yeah, it's just they're going to get the training that they need in a Baptist seminary that they won't get in a Catholic school. All right? So you get the idea. Now, how do you prove that? One of the ways you prove that is by statistics. All right, and somebody asked me a question on statistics. There is basically what is called a 4/5 rule, okay? And if you can show that 4/5 test, and I'll give that to you in just a minute, but if you can show that 4/5 test statistics, then you may show discrimination automatically, okay? Here's what the 4/5 rule says. If these, and let's talk about this as if we're hiring people, because that's where it's going to come into play. If the selection of the group with the lowest rate, okay, so if the selection of the group with the lowest rate is less than 80% of the rate of the group with the highest rate, a disparate impact is presumed to exist. Okay, give that to you. Yeah, absolutely. 4/5 rule. Here's what the 4/5 rule says. If the selection rate of the group with the lowest rate is less than 80% of the rate of the group with the highest rate, a disparate impact is presumed to exist. Now, let me give you an example, because that's where this is really going to come in clear. Let's say that you have an entrance exam. Well, let's just go back to being a teacher. All right, we'll get rid of our 6'1", 6'2" requirement. All right, you're just going to be a teacher. All right, but there is an entrance exam that if you're going to be a teacher, that you have to pass. Okay. If the pass, let's say you have 100 total for males and 100 total for females. So 100 men take the test and 100 females take the test. All right. Let's say your males 85 pass. Okay. So what percentage of your males pass? 85%. All right. Let's say that females, let's say you only have, let's change this a little bit for my math purposes. Let's say you only have 50 females apply. Okay. Let's make it only 50. And let's say out of those 50 that apply, only 32 pass. Okay? And you have 18 that fail. I want to ask you to do the math in your Yeah, very good, Tom. 64%, okay, of your females passed. Now, if you take, let's see if you want to do this one in your head, 80% of the 85. So you got 85% of your males that pass, all right? What's 80% of that number? It's going to be, I'll just give it to you, it's going to be 68%, okay? So you take your highest passage rate, if you will, on your test or whatever it is, and if you don't come up to 80% on your lowest passing rate, then you've got a problem. So back to our example, if 85% of your males pass and 80% of that is 68, but only 64% of your females pass, you have discrimination. It's presumed to exist. Okay? It's presumed to exist. That's an application of that 4/5 rule in effect. So, statistics, the 4/5 rule is one way to determine disparate impact. Frequently, we may look at this in the case I give you when we get into age discrimination. That statistical analysis is required. You can't just say this test is going to do it without putting some kind of expertise behind it. Okay? All right. Now, the other ways you look at these tests, and when you look at tests, and if you're in the management and you're assigned the job of developing tests, you probably don't want to develop them yourself unless you really know what you're doing. You probably want to go out there and purchase tests from companies who provide them. But there's a couple of ways that validity that I want to talk about. And we'll talk about how do you determine if the tests are valid or not. Let me give you some types of validity. Content validity. And I won't spend a lot of time here because we're not doing validity tests, but I think it's still important with regard to determining them. Content validity, okay? Construct validity. And then criterion validity. And let me give you what those are. Content, construct, criterion. When you look at content validity, here's what you're basically looking at. You're trying to determine if the questions on the test are representative of what you're trying to measure. Okay? Are the questions on the test representative of what you're trying to measure? Let's go back to my teacher analysis or analogy, okay? I want teachers who are going to be good teachers. So I put on the test, is your height, are you above 6.1 or 6 feet 1 inch? All right. Now, does that measure whether somebody's a good teacher? Absolutely not. We've already covered that. Okay? Not at all. So that particular question doesn't measure it. Somebody give me a question that might measure it. Yeah, Amanda?
Oh, I have no idea.
Okay.
Just something that would have to do with teaching. I mean, what's a good classroom size? Or
Yeah, I mean, yeah, give me an essay on classroom size or which, yeah, something that has to do with teaching. I mean, it can be anything, okay? And you're not going to give a test that generally just has one question. You're going to give a bunch of questions on the test. But that's what content validity is. Construct validity, on the other hand, is are we measuring what we think we're measuring? Okay? It's a little bit different. It's are we measuring what we think we're measuring? In other words, if our test is to measure achievement, are we really measuring achievement by the questions that we ask? Does it properly measure what it's supposed to measure? And it looks at the overall test, whereas content may look at the very specific questions. Okay? If we want, let's go back to height. If I want to know my height, what am I going to use? A tape measure or a bathroom scale? I'm going to use a tape measure, right? Because bathroom scales don't measure height, all right? It's the wrong construct, okay? Does it measure what you want it to measure? The last one is criterion validity. It basically determines whether a test or a state test or a measurement reflects a certain set of abilities. Now, where it differs from the other is it has to compare it. This is after it's done. You can only do it after it's done, looking backwards. All right? So does it measure what it's supposed to measure? Give an example. If you're trying to measure whether the students in Law 531 are more likely to vote Republican or more likely to vote Democrat, okay? You would want to measure that against people who you know are going to vote Republican or going to vote Democrat. And you want to find out what the criterion is for voting Republican and then measure that against the students of Law 531, okay? And you want to make sure that you do it. You can do that with a known standard, okay? And you can also then come back later on and see when you're measuring it, it just doesn't stop there. These aren't measured or tested at one point in time. Then you come back after the election and say, how did you vote? And you compare it, okay? Give you an example of where this may not be old enough. I don't know. Coca-Cola. Remember when Coca-Cola came out with there was original Coke and there was new Coke? Are we beyond new Coke days? Wow, you're all looking like you've never heard of this before. Ah, okay.
I know what you're talking about.
Thank you, Darla. I appreciate it. It is nice to have another old student. No discrimination intended. No, they came out and they did some tests, okay? And they did some tests with this new Coke to see if people liked it. And a lot of people liked it, all right? Here was the problem. They didn't test it again, so they go, okay, this measures whether people are going to like it, and they immediately said, we're going to go sell it. The problem is they didn't have a test comparing it to old Coke, okay? So people liked it, but not old Coke users or drinkers, okay? It was one of the biggest marketing failures, all right? Same thing with your employment tests. As you do these tests, and they're becoming more and more prevalent, if you will, when you give these tests, you want to make sure that they measure what they're supposed to measure, okay? Now, your defenses to the impact case are, again, business necessity. Okay. You may also, one other defense that you can have, and again, you've got the failure to exhaust the administrative remedies, you got the statute of limitations, but the other defense, pretty unique to the disparate impact, is bona fide seniority system. If you have a bona fide seniority system, okay, and based on that system, you're discriminating against people who have not been there as long, that still may be okay. Mention a case very briefly. We won't spend a lot of time on it, but we talk about firefighters in this class. There's a case out there of Ricci versus De Stefano. DESTEFANO. I'll spell it again all the way. Ricci, RICCI, versus De Stefano. DESTEFANO. In that particular case, a group of white males filed a lawsuit against a city who had given entrance exam tests for being firefighters. All right? Now, here's what happened. In that case, the white males actually scored higher than their African American counterparts. But the city threw out the test and the results because they thought it was going to be race discrimination. And the Supreme Court came back and said, you can't automatically throw it out without doing certain testing of it, okay? And without really looking at it. Just because more whites, Caucasians, pass it than African Americans doesn't mean it's necessarily bad. And so you can't, and the reason for throwing it out was they were fearful that they were going to get sued by African Americans. And the court said, we're not going to let you do that, okay? You can't do that. You have to look at the test. You have to determine, is it valid or is it not valid?